You ever hear that old phrase, possession is 9/10 of the law? That may be true for cars and couches, but when it comes to protecting your wealth from lawsuits, the game is completely different. And in today's video, I'm going to show you exactly how we structure a trust legally, ethically, and powerfully so that even the most aggressive creditor, attorney, or court judgment couldn't touch your assets. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. We've helped tens of thousands of clients protect their wealth, and we've established more Cook Islands trusts than anybody in the world. And if you're serious about safeguarding your financial future, be sure to subscribe if you haven't already. I bring decades of insight that you won't get anywhere else. Let's get right to it. Here's the problem. The more successful you are, the more of a target you become. I mean, it could be a lawsuit from a tenant, an aggressive attorney, in a car accident case, a disgruntled ex-business partner, even a professional malpractice claim. The lawsuit doesn't have to be fair. It doesn't even have to be true. The legal system allows someone to file a suit and put you on the defensive, forcing you to prove that you're not guilty, while your wealth hangs in the balance. And insurance? It's important, but it's really not enough. I've seen it. Insurance companies look for reasons not to pay, and the moment they can find some kind of loophole, you're on your own. And that's why smart people, especially high net worth individuals, build a legal structure that doesn't rely on luck or hope. So let's talk about a tool that does exactly that, an asset protection trust. But not just any trust. We're talking about a Cook Islands trust, a Belize trust, or a Nevis trust, arguably the strongest asset protection tools on the planet. Now, if you're new to trusts, here's a quick breakdown. A trust is a legal agreement where one party, the trustee, holds assets on behalf of another, the beneficiary, and in an asset protection trust, you, the person setting it up, is called the settlor. And when done right, the trust can separate your legal ownership from your personal assets, making them unreachable by creditors. But here's the key. U.S. courts can force you to hand over assets in a domestic trust. Offshore, the rules are different. U.S. judgments don't automatically apply. So why the Cook Islands, Belize, and Nevis? So why an offshore trust, especially one in the Cook Islands, our favorite? Because it's one of the only jurisdictions in the world that does not recognize U.S. court orders. Requires creditors to file a brand new case in person in the Cook Islands, uses a beyond a reasonable doubt standard for fraudulent conveyance, not a preponderance of the evidence like in U.S. courts. And what that means is somebody wants to sue you and go after your assets, they have to hire a Cook Islands attorney. They have to fly 7,000 miles to a tiny Pacific island, pay a non-refundable retainer, often over 6 figures, and re-argue the entire case from scratch. And they must do all of that under their local laws that heavily favor the asset owner, you. Now, it's not impossible, but it's so difficult and expensive that 99.9% of the time they give up. Now, here's where it gets really interesting and strategic. We don't just use a Cook Islands trust by itself. We place a Cook Islands LLC inside the trust, and guess what? You're the manager of that LLC. You control the bank account. You can move the money, invest, pay bills, go online, do your stock trades, just like any other LLC. So how's that protective? Because the trust owns the LLC, not you. And our law firm, licensed and bonded in the Cook Islands, is the trustee company. So we don't step in unless a legal attack occurs. So think of it like this. You drive the car as long as the road is smooth, but if a lawsuit hits, we legally remove your hands from the wheel, take control, and move the vehicle to safety outside of the jurisdiction of the U.S. courts. So that's what makes this structure lawsuit-proof. It's like having a secret financial bunker that no one else can access, even if they know it exists. So let me give you a real-world example. We had a client, let's call him Dr. Michael, a successful plastic surgeon in California, and a patient filed a malpractice suit. The claim wasn't just about physical results, it was emotional trauma, and emotional damage claims, they're subjective and open-ended. His malpractice insurance denied the claim due to a technicality, and the patient's attorney smelled blood in the water. They came after his practice, his home, his retirement accounts, everything. But guess what? Dr. Mitchell had already worked with us. His Cook Islands trust had been in place for over a year. His business was owned by a domestic LLC, his offshore LLC inside of his trust, and when the creditors tried to collect, there was nothing to take. His trust had already stripped the equity and locked it away offshore beyond their reach. The case eventually settled, but it was for pennies on the dollar. Why? Because the attorneys saw they weren't going to collect. No payday, no incentive to keep fighting. So this is where a lot of people get nervous, understandably. You might be thinking, won't a judge just say I moved assets to hide them and reverse it? That's called fraudulent conveyance. But let's clarify what that actually means. Now, fraudulent conveyance is when somebody moves assets after they've already been sued, or after they know they're going to be sued, or when they're actively trying to stiff a known creditor. So that's why timing is really everything. So we tell our clients the best time to set up an asset protection trust is when the waters are calm, not when you're in a storm. Now, we can set it up when you're in a storm, but it's best to do this beforehand. So once a Cook Islands trust is funded and seasoned, it's nearly impossible for a creditor to reach it even if they scream fraudulent conveyance from the rooftops. In fact, the Cook Islands law says if the creditor doesn't sue within a 2-year window, or if they can't prove fraudulent transfer beyond a reasonable doubt, the trust is untouchable. I mean, let that sink in. Beyond a reasonable doubt, that's the standard used in criminal trials. That's like 97% to 3%, where most cases are by the preponderance of the evidence, like 51% of the evidence compared to 49%. So that's a nearly impossible bar in civil litigation. Now, you may hear about domestic asset protection trusts in states like Nevada or South Dakota, and yes, they are better than nothing. We set them up if somebody jumps up and down and stomps and says that's what they want to do. But let's be honest, if a U.S. judge wants to break open one, they can. Why? Because they're still subject to U.S. courts, U.S. judges, and U.S. politics. In fact, there have been multiple cases where judges simply said, turn over the money or go to jail for contempt, Mr. Trustee. And if that trustee has a decision to either turn over his money or your own, you know what that decision is going to be. The guy doesn't have any choice because they're U.S. based under the jurisdiction of that U.S. judge. And if the trust is governed by the same country issuing the judgment, well, good luck. Offshore is different because the trustee is not in the U.S. and because the trust is governed by a foreign law. A U.S. judge can't compel compliance, and that's the firewall, the jurisdictional barrier that gives your wealth real protection and not just paper protection. Okay, now let's bust a few myths. Myth number 1, offshore means illegal. Wrong. A Cook Islands trust is 100% legal when properly structured and reported. We follow IRS guidelines, we use licensed trustees, and comply with all disclosure requirements. Myth number 2, you lose control. Also false. As long as there's no legal threat, you're the manager of the LLC. You run the show. If you need somebody to step in to protect you, the money would be gone anyway, and the courts would take the money. So we have our licensed bonded trustee company law firm step in to protect you when you need them to. Myth number 3, only billionaires need this. Nope. We have clients with a $1 million net worth and clients with a $100 million net worth. You've got something to lose, it's worth protecting. Myth number 4, I'll just use an LLC or a corporation. Now, limited liability only protects against certain risks. It doesn't shield personal assets. A trust is what defends your wealth when somebody comes after you personally. Now, if there is a lawsuit inside of a corporation, for example, that lawsuit may stay inside that corporation, not jump over and touch you personally. But when somebody sues you personally, they can come after your assets. They can even come after that corporation, take the corporation away. So a corporation only provides one-way protection. An LLC can provide two-way protection, but the problem is U.S. courts penetrate them all the time, and there are always exceptions to the rules, and there's also constant changes to the way the law perceives the protection, and the increasing theories of legal liability makes it so that you become more and more vulnerable because the laws and the way the laws are interpreted always tend to move in the direction of taking the money out of your pocket and putting it in the lawyers' pockets because they're the ones arguing these cases over and over again, really setting the case law, working with the judges. Now, here's a quick word about how we do this differently. At the Lawyers Limited Law Firm and Asset Protection Planners, I've been doing this for 34 years. I've personally been helping people set up Cook Islands Trust for nearly 30 years. We don't hand you a stack of documents and wish you luck. What we do is we guide you through it step by step with a live onboarding call, a video call. Our team helps you, our legal team helps you move funds, explain logistics, go over the paperwork, and ensure everything is 100% compliant. So it's really white glove service. And because we've set up more of these trusts than anybody on the planet, we've seen every strategy, every trap, every workaround, and this isn't just theory, it's battle tested in practice. So here's the takeaway. It's not about hiding, it's about protecting legally, strategically, and before something happens. So think of a Cook Islands Trust as your financial firewall. You hope you'll never need it, but if the day comes when someone tries to take what you've built, you'll be glad you prepared when the waters were calm. So if this resonates with you, if you've built something worth defending, you can visit us at assetprotectionplanners.com to learn more. And remember to subscribe if you haven't already. I bring you decades of experience boiled down into clear, actionable insights that you won't get anywhere else. So thanks for watching, and we'll see you in the next video.